Welcome to Conflict to Connection, the podcast that helps families navigate separation with compassion and understanding. I'm Mitch, a child consultant at Civilised Separations, and I'm joined by my co-hosts, Bill and Bella. Together, we tackle tough conversations about divorce, co-parenting, and creating healthier family dynamics. Whether you're navigating a separation or just looking for better ways to connect, this podcast is here to guide you every step of the way. Welcome to Conflict Connection. I'm your host, Mitch Wilkins, a child consultant at Civilised Separations. And today I'm thrilled to be joined by Bill Hewlett, a lead post-separation specialist and one of our regulars on the podcast, and Helen Adams, one of the UK's leading voices in the mediation space. She's a founding partner of Wells Family Mediation, who has won numerous awards for her work in family and child-inclusive mediation. Helen started out as a solicitor before making the move into mediation and now works with the Family Solutions Group, leading vital policy work focusing on changing the laws around divorce to become more child-focused and less adversarial. So welcome and thank you for coming on.
Thank you.
So Helen, let's just get stuck into it. You qualified as a solicitor in 1990 and retrained as a mediator in 2007. What made you make that decision?
Gosh, it all feels rather a long time ago now. Thank you, Mitch. So I read law at university and started out in a commercial firm doing litigation and realised it wasn't my ticket at all. I was doing intellectual property, heavyweight litigation, moved into family law, absolutely loved it. And then after a few years, I took some time out. My first child arrived. And I remember looking at this little baby in my arms and thinking, I think I might need to find another way of working, because if I go back into that dynamic, I'm for the one parent. My colleague acting for the other spouse is for the other parent. And who in that dynamic is there for the child? And there's that moment when the love just flows for a new arrival. And it got me thinking about where is the child's voice, interests, needs, welfare represented in the traditional format that I was working in. So I was out of the workplace for a little while. And someone I knew was running a divorce and separation recovery course at a local church and said, oh, you know about family law. Can you come along and do the talk for us on family law as part of our course? So I thought, great, that'd be great. Keep my hand in. And went along, arrived feeling very much that I was the expert. And it was a fantastic course. And I sat in the small group and I listened to probably 7 or 8 adults talking about the issues they were facing. They were talking about difficulties around communication. They were talking about how to establish boundaries. They were talking about loss, about grief, anger. They were talking about the challenge of having to let go of some of that so that they could co-parent with the other person. Co-parenting obviously wasn't a term then, but, how to protect one's children. And I sat there and as I listened, I realised how completely de-skilled I was in that group. And yes, I may have incredible knowledge about the law. I'm a law expert. But if you think of a pie chart, what a very narrow slice my legal skills could bring to the conversations taking place. And I realised again, if I needed to go back into this work, I needed to develop some skill sets that could be more relevant to the issues that people are going through when they separate. And I would say that the really important things that I've learned in the kind of evolution of a kind of toolbox that one develops over life in this field, it really come from all the non-lawyer things I've done, mainly sitting in those workshops, and then all the other training, the mediation training and other training that I've done to what the kind of legal world sometimes rather rudely calls soft skills, but they are the essential skills.
Yeah.
And the legal bit maybe are the hard skills.
So you went back to being a lawyer again after being away from work for a little while, and you were then repracticed as a mediator, or there was a period of time where
I did some part-time work in the firm, but I stopped effectively acting for a parent from that point onwards.
Wow.
And then I retrained as a mediator.
And so then you were
So-
kind of practicing as both. So that kind of duality,
No.
just as a mediator.
I trained as a mediator in 2007 and didn't look back.
Wow.
I never went back into legal practice after that moment. But I mean, it was me coming back into the workplace. I wasn't trying to juggle two jobs. I think
Yeah.
many people that train as mediators are already in practice as solicitors,
Yeah.
and then they gradually,
Build up.
develop a kind of career alongside a dual track. I was just coming back out of not working at the time.
Yeah.
So then, yes, just mediation from then on.
Wow. And so when you kind of made that transition into just doing mediation, were your peers kind of shocked by that? Did they think, why on earth are you doing this?
No, not really, because at the time I was a solicitor in a great firm, Anthony Gold, and one of the partners, Kim Beatson, was an absolute pioneer as a mediator. She was one of the early mediators. So actually mediation was a known thing back then, but no, it wasn't a sort of totally shocking.
And I was just wanting to see if you could tell us a little bit more about the Family Solutions Group and why you got involved in it, and a little bit more about it before we move on.
Well, the president of the Family Division asked Mr. Justice Cobb to set up the private law working group to make recommendations to improve the system for families going to court around their children arrangements. So this wasn't about finances. It was all about applications for, regarding children in private family law. And Steve and Mr. Justice Cobb put together an absolutely fantastic group of very, very experienced people, ranging from High Court judges to all kinds of everybody, academics, MOJ, legal aid, assistant barrister. I was the mediator representative in that group. Much of the discussion and indeed the reports that they wrote were about the actual court process, managing gatekeeping better. A huge thing that came out of it was the risk of harm panel report and the experience of many people who are victims of domestic abuse in the family court system and how bruising that's been.
Right.
And the other thing that came out of the private law working group was the introduction of the Pathfinder courts, which are now hopefully rolling out elsewhere. So that was all about how to manage the court process better. But one of the findings of the private law working group is that too many parents are ending up in court. There's a lot of argument between academics and judges at different levels about what percentage of families turn to court should be there and what percentage should be elsewhere. But at least around 20% of parents turning to court probably should be helped elsewhere rather than in court. Some people would say it would be more. Now, the experience of everybody around that table, the incredible wisdom of that group, was all from the filing of a court application onwards.
Right.
I was the only person there who had any real experience of working with families away from a court system. And I said, really, you need a different group if you want to have a careful sort of look at what families need before they come to court, because this group has no experience of that. And it's one of those moments when afterwards you slightly regret opening your mouth.
You set yourself up.
But, it's a great idea, Helen. We'll call it the Family Solutions Group, and who should be on that. So that was the beginning of the Family Solutions Group. It was made up of different professionals representing different needs in the family solutions space. But this wasn't a group of lawyers and barristers and judges.
Yeah.
And it wasn't just mediators either. There was Judith Timms from the National Youth Advocacy Service, with Dr. Jan Ewing, who's an academic. We had Elizabeth Coe from the National Association of Child Contact Centres. We had people feeding in from different areas. And, everybody was focused on what do families need in the family solutions space. And very quickly it became obvious that everybody's focus was on improving outcomes for children.
Yeah.
And it wasn't a parent agenda. And recognising the deficit, really, of any advocates for children in the private law space. None. Which I would say that again, because it's actually quite shocking in our society. When you think of all the safeguarding and everything that's going on to promote children's welfare and their mental health and well-being, we know all the evidence about how children are harmed when separations are managed badly and parental conflict. In spite of all that we know, there are no advocates in the private family law space for children. that there is nobody that holds the government to account for the first principle of child welfare. It's there in the law, but there's nobody that checks that. So we sort of filled that space. It wasn't what we were set up to do, but very quickly it became obvious that
That's what was
a
needed.
shared set of values. Yeah.
Wow.
I've often wondered why the child's voice is kind of not naturally listened to. I think I kind of wondered whether, in a way, keeping children out of it was seen as preventing the children from being traumatized, or a sense of, if you ask what their voice is, they might get upset. And what will we do if they're upset? There was a real sort of sense of tentativeness around.
I also think it's part of the prevailing culture where our legal system fills the space. And lawyers are, there's no criticism of them, it's their training. They are trained to be positional.
Mm-hmm.
They are trained to represent only one client's interests. Of course, we know loads of wonderful lawyers who see beyond that and want to uphold kind of good outcomes for the whole family. But their training and their professional responsibility is to one parent. And I certainly came into this discussion around children's voices thinking, I'm not trained to work with children. And my job is to help parents manage things in a civilised way, civilised separation. And if I do my job well, then that will have knock-on benefits for children. And that was my thinking. And I think many, many legal professionals would see inviting the voice of the child as an inappropriate pressure for them to take a side. Now, of course, you and I, Bill, know that doesn't happen. And Mitch, sorry, it doesn't happen. Children don't have family life experiences in terms of sides. But that's the lawyers projecting their own understanding, their own context of family separation onto a child. And I think that makes a lot of people very, very nervous about it. But sitting around the family solutions group discussions, listening particularly to Judith Timms and to Dr. Jan Ewing, I was properly challenged. And now I would say, I feel really sad that I've gone through all these years of my career, and it's only in the last 10 years I'm really, really emphasising the voice of the child in all my practice. But I would say it's like a three-legged stool. And when we were only with two parents, we've got the third leg missing, and it's imbalanced, and the outcome may not actually work brilliantly for the family, but you get the child's view in there, and everybody's working to, an outcome which encompasses. They may or may not agree with what the child says, but I think it just is essential for the work we do. I'm a complete convert.
Yeah. And so speaking of the child's voice, here at Civilised Separations, we use child inclusive mediation for every case pretty much that we have, and you've done that for years, Bill, and you now do this as well in all your standard practice too. And it's kind of that important stepping stone. We're talking about how important it is to bring in that child voice. But do either of you have an example where you noticed in a case or with a client that the child's voice really changed things in child inclusive mediation? I'm sure you've got many, but
all of them.
Almost, I was going to say pretty much all of them. It introduces. I often feel that it introduces a bit of brain that's otherwise not working in the parent, and when they sort of are helped to remember that they've got children and remember that their children are making sense of everything and deciding who they are themselves based on the environment around them, then they step into a different state of mind. It seems very counterproductive to me to ask people to sit down, talk about arrangements pertaining to their children without having access to that part of their brain, without them thinking, hang on, what's my job here? What sort of world do I want to live in? What sort of child do I want to have? To not have that sense of perspective whilst deciding the life of the child makes no sense at all.
So just in case the audience don't know, can you tell me a little about what child inclusive mediation is and the safety around that and how it's worked?
It's an opportunity for a child to speak freely and openly in a confidential setting about anything that they're experiencing. What do they like? What's going well? Mm-hmm. Is there anything that's particularly important to them? Is there anything they find tricky? Is there anything that they really want us to be able to chat with their parents about when parents are thinking about decisions? So these are very open questions that give a child the opportunity to say whatever. I mean, I had a really interesting chat with one lad, and he talked quite a lot about carrot cake. For some reason, one of his parents had got it into their head that carrot cake was a really special thing for him, and we just make it, for special occasions.
It's
Done
red
really
hair.
well. Yeah, I don't know. And he really didn't like carrot cake.
Oh, yeah.
And we had a really hilarious conversation about how I could sort of slip that in without him, because he didn't want to let his parent down, and how I could sort of slip that in, that actually maybe that wasn't always the thing. And, we actually had quite a laugh about it. So the opportunity for a child to meet a mediator, let's just be clear about it. Number one, is a human right.
Yeah.
It's there under the United Nations Convention on the Rights of Children, to which the UK has ratified that treaty, Article 12. More important than that, parents have the opportunity to go and have private conversations with a solicitor, with a mediator, with a therapist. Children don't naturally get that. They may be able to talk to a therapist, but that doesn't automatically allow them to feed back their views.
Mm-hmm.
This is a confidential discussion. And at the end of the confidential discussion, we say to the child, how much of that are you comfortable for us to feed back?
Yeah.
Would you like us to say that? Would you like us to say that? And they say, yeah, you can say it all. Or actually, can you not say that? Or sometimes, could you say that, but could you say it nicely? Maybe
so they
about a carrot
always
cake.
seem to understand the idea of confidentiality and saying
Absolutely.
that actually
Yeah.
this I'm not comfortable with, but this I'm okay with.
Yeah.
They seem to intuitively understand that when you tell them about confidentiality.
Yeah.
They just nod. Yeah, of course I get that.
They get it.
And also you can, just like their teachers, if we hear anything which leads us to think that somebody's at risk of harm, we're under a duty to report, like their teachers are. But
Mhm.
otherwise, everything you say here stays here unless you give me permission to pass it on. So I had a really interesting chat with one young girl. She was really keen on swimming. Now, after swimming, she liked to wash her hair twice with shampoo and then with conditioner, because if she only washed it once with shampoo, the chlorine might not all come out. She had beautiful, lovely long hair. So let's wash it twice with shampoo to get all the chlorine out, and then the conditioner. When she goes to her dad's house, he says he only provides the combined shampoo and conditioner together.
Oh, dear.
Yeah. And interesting. And I said, well, is that something you'd like me to go back so that, at least we could see whether you get separate shampoo? And she said, no, I don't want you to. Because things were really bad between her parents, and by her feeding back that, it was entering into the conflict between them, because the mum had told the dad to do it and the dad had refused.
Yeah, so it's the small things that they're saying, I can't even ask this.
Yeah, it was really interesting, because there have been times when children talk for an hour and a half, just all it can, and then I'm sure you've had this too, Bill, but at the end they say, I don't want you to say a word.
Yeah.
I don't want you to feed back a word. Now that is, in my view, is very, very powerful feedback.
Yes.
And you can use that power
Why?
with the parents, even
Absolutely.
still, even if everything has to be confidential in your professional opinion. Why can nothing be explained?
Exactly. What does it say to the parents about the childhood experience that they don't want a thing to be fed back?
Yeah.
And what would you, it's led to some interesting parent conversations,
Yes,
hasn't it?
absolutely. I remember one kid, I think he was about 13, and he looked very sort of groovy and had a very cool haircut and looked very sort of, like a kid who really was kind of probably very popular.
Mm-hmm.
I came down to the waiting room, and he was kind of joking with his mother, I think he was with, and kind of mocking me somewhat, like, who's this? And he was following me up the stairs and kind of looking back at them and said, what a joke this all is. And then when he sat in the room, he started to talk about how he really felt. And it was such a radically different character to the one who'd sort of demonstrated. So clearly he's kind of learning that his mum needed to see him looking
Jovial,
bubbly and happy and everything's amazing, but actually inside he was really hiding a lot of sadness and a lot of sort of deep thoughts and feelings and sort of insecurities. And so to find a way to get her to kind of see what she wasn't otherwise being allowed to see by him was very helpful, because she was going along with what she saw.
Yeah, so it can be often that parents think, oh, well, they're fine.
Yeah.
Whoever it is, Michael, he's not bothered. We've kept it away from him and we've tried to keep him out of it. And, he seems okay when we're with him, but actually, really, it's affecting them a lot more than you think.
Yeah, and I think that it goes back to something Bill said just a little bit earlier about accessing that part of the brain. There's a word that you won't find anywhere in any legal textbook in the whole of family law, and it is love.
Wow.
There isn't enough said to give parents just permission to think about the love they have and to talk about love. And I find that when we listen to young people and what they have to say and we feed it back to parents, if I can use the metaphor of a tug of war, they're there pulling against each other, arguing about whether they're getting this night or that night or whatever, They put the rope down and they just are free just to listen to their child, the authentic views of their child. And just, the fact of the matter is most families, most parents that we work with, love their child. They love their child more than anybody else, probably more than themselves.
That's why they're in conflict, because they care so much.
That's right. And it's allowing the kind of love that a parent has of for a child to come to the fore. And actually, now let's talk about, what do you want for your child? Whereas when it's framed in terms of rights, which of course is a complete flawed misunderstanding of English law in any event, but there we are. But, parents have responsibilities more than rights. But somewhere in that, we want parents to be free to love their child and to make space for the other parent to love their child, because that is loving their child, if that makes sense.
Yeah, and they explain that through the mediation process, that actually the child becomes happier if the other parent is happy.
Maybe.
And therefore that creates space for the child to be whatever they want to be and who they want to be. And
yeah. I wonder if there's a cultural thing here, and I'd be interested in your views, Bill. We British people don't sort of talk about love a lot, but I had the great joy of going to someone's 60th the other day. I'm at that stage in life, unfortunately, and it was South African, a lovely guy, and his South African mates, these are all big, strong, hardy guys, oh, we love you, you're our best mate, and there was genuine expressions of love. And I thought, I've been to quite a number of English 60ths and I haven't really kind of heard that. I don't know what happens in Australia, but
yeah.
I have said the same thing multiple times actually about how I feel like maybe it's a cultural thing, why the British not really taking up enough about wanting to say how they feel or be emotional. It's kind of this stiff upper lip. We must be this certain way and we can't say that we love someone, and that it's like kind of the humor is always really dark, and we kind of take the piss out of being too emotional.
So bringing emotion into the process, be it mediation or even family law, allowing people to be moved and be emotionally motivated will actually smooth the way and make a lot of other, which would otherwise be very complicated situations, suddenly incredibly easily solved. So I was kind of thinking about, I can remember when I first came to England, going to conferences and listening to talks about, the situation in relation to family law, and feeling this sense of everybody wanted the situation to be different, but somehow knew it wouldn't. It was kind of like wading through treacle. It was very distressing. And if it's sort of coming from a place that they actually started to do stuff and then be in a place where people are saying they'd like to, but a real sense of, but we probably won't. And I guess, government must be to a large extent, there's not much direction down from government saying, change needs to happen. You get small pockets like you were talking before of people saying, this is not good, but there seems to be an inertia.
I don't know if it's an inertia. I think I would say it's more of a blind spot. I walked into that workshop in 1997 or 8 or whenever it was, thinking that I was the expert. I had to learn that actually, I was properly incompetent in understanding the wider needs of separating families. But the point is, we live in a society which has a very heavy dominance of law and of the overbearing presence of the family court on the horizon. And that is the message. And in our Family Solutions Group report, our key recommendation was that there should be someone appointed with oversight across government departments, because the needs, I'm going to say not of the separating family, but of the child of separating parents, it goes beyond law. Now, some families absolutely need the family court. They are vulnerable. They need the protection, and the family court plays an incredibly important role. And I would also say that I think the judges that sit in the family court have an incredibly tough job.
Yeah.
But, or
should it be in court at all? I mean,
well, some cases should. Some cases need to be in court for protection. That's another conversation, Bill.
Okay,
But maybe
let's
let's not
go
go.
there.
But let's think about all the families who've just unravelled and who've ended up unwittingly there. I would say that the people that know how to shift mindsets so that families are helped to their own solutions, to be thinking about love, to be putting down the tug of war rope, to be engaging with what their child is saying, and to be looking at solutions. Judges don't have experience of that. They have literally no experience of that because they're court specialists.
Yeah.
And the absolute tragedy for me in all of this is that we don't have multi-government oversight, notwithstanding repeated requests by us and many others over many, many years. It's anything to do with family separation is left with the MOJ. And the only people who the MOJ consult...
Can I just ask for people that don't know what the MOJ is?
The Ministry of Justice. The Ministry of Justice have a very, very important role, apart from prisons and everything else. They have to run the family court.
Yeah.
And that's important. And it's important and that they do it well. And as I say, the judges that sit there have an incredibly difficult job, and I have a lot of respect for them. But it's not expertise in family solutions.
No.
The sort of work that the three of us do is quite different. Now, I would not, having been away from family litigation for, 35 years or whatever, I would not hold myself out as anybody expert to talk about what goes on in court. I wouldn't. That's not my field. So I find it galling and a blind spot that judges and barristers seem to think that they are experts in what the MOJ calls the earlier resolution of family cases.
So why do you think that mindset's there? Why do you think that is? Why do you think that, for example, you thought that you were the expert on it when you first went in? What do you think that's creating this
It's the
idea?
dominance of law in the whole context of family separation. We need to move away from law. We need to get back to love.
Interestingly, the idea of law and relationship at all goes back to ecclesiastical law times when the family were the property of the man.
Yeah.
And because it was a property issue, the law got involved. So I think we've moved away from the idea that families belong to anyone. And yet there it is, the law's still there and still the first port of call.
I long for there to be a directory of family solicitors who have that essential skill set, so that somebody would be able to say, right, I want a civilised separation. I want a family solicitor that understands the need to protect and value and respect the nearly 40 years that we've had together and our adult children and everything else, and is not going to use the old-fashioned way of sending letters, and if you don't respond by then, we'll start court proceedings.
Yeah.
That's the other thing I think which is important to say, is that the government brought in new rules in April 2024 so that all lawyers are now expected to read the pre-application protocol with their clients and talk through all the different options for resolving issues away from court. And I think very few lawyers and barristers are actually reading those pre-application protocols with their clients.
I wonder even if they did, whether the mindset that they bring, the way that they learn to think, whether those words would actually translate into anything of any sort of meaning. I kind of feel like the way everyone's been taught to think, I remember someone telling me that halfway through year 2 of law school, your mind is changed and it's never the same
Really?
again.
Oh dear.
And it kind of, Well, of course, you can change it if you want to, but I think a lot of people don't feel the need or the urge to. So there is a significant problem whereby you could have even legislation, or you can have groups, sort of processes that look at what the problem is and do research and write reports on it. But if the people that are reading it have a particular kind of mindset and a particular way of interpreting, that's where the problem stays
So true.
in place.
Everything in our society around family separation by those in authority is filtered through the lens of law
Yeah.
rather than love.
Yeah.
There have been multiple times when we've asked for this, we've tried that, we've done that, and we've, been ignored. Fine. In fact, every single one of our recommendations has been ignored by the MOJ because the people that they look to for advice are a legal group of advisors, and we're trying to get them to think in non-legal mindsets. We're trying to promote.
So this
a
shift
mindset
from justice to child welfare isn't happening because of the mindset of those who are putting in the implementation.
People mean well, but the MOJ need to think that the legal structure is not the answer to the early resolution space. The definition of early resolution is it's before court. Therefore, court rules aren't the thing that operate. You need, we're using, the voice of the child and all kinds of other techniques to help parents shift mindsets and be free to come to their own solutions. But, it's like asking the wrong set of advisors to guidance for a different skill set.
So do you think that psychologists should therefore be the first port of call for family solutions, and mediators and child inclusive mediators as the first port of call rather than solicitors and lawyers and barristers?
Well, there's a backdrop of the family court on the horizon if people can't resolve things. But yes, every family law department should have a psychologist in there, because the things that we are primarily dealing with are human psychology. And certainly a child psychologist needs to be there. It's extraordinary that we don't have a proper assessment tool to assess child welfare.
Yeah.
We need to have a framework for how it says child welfare is of paramount importance. In the out-of-court space, how are lawyers assessing child welfare? We need the psychologists informing our practice, and we need the mediators. I actually think divorce coaches play a really fantastic role in this space in terms of helping parents stick to the goals that they have and not let their own hurly-burly derail them. So there's a whole range of people that are working in the family solution space, promoting civilised separations. They are the experts in the earlier resolution space, and they need to be guiding. But unfortunately, what happens is you get a group of lawyers working out, what does non-court dispute resolution look like, and they come up with a bunch of legal options. Well, many people in the country can't afford them. That's another thing about language. The Family Solutions Group published a paper on language a few years ago, just trying to humanise it and take out the legal jargon and
talking about the sort of bios that the lawyers put on their kind of.
No, I'm
CVs.
talking about the systems. I'm talking about
not being able to understand what you're reading and
legal jargon,
getting
the parties, contact, dispute. When we disagree with our significant others, it's not a dispute. We may have a difference of view, and I actually think difference of view is very, very healthy, and I praise the clients we work with if they don't agree on something. That's great, that's healthy, that's normal, and it's actually great for their children to learn that parents don't always agree, but sadly it gets reframed as conflict.
What I love about you bringing up that language, I had a look at that article as well, and I really loved the fact that you were talking about language being so important, because what we always talk about, or what you train me to talk about as well, is that positive language, and coming into having this couple who have gone, they might have been through the court processes and it had been very negative and not a great experience, and then they come to you and you kind of have this positive air, this sense of light that things will be okay and we will work this out. And actually you use positive language and you use positive reinforcement, and it settles them almost instantaneously when they're in the room.
Thing that so much, and I think this applies to mediation as well, or the mindset that the clients bring to mediation, where there is this rather pessimistic kind of expectation about how life will be, almost like the separations happen, which is a reflection of failure of some sort. So everybody's rather sort of gloomy about what's happening, rather than being very excited about what the future might be like and how the new shape of this family could actually be much more suited to them than it has been in the past. So so when there's no articulation as to how good life could be, how on earth are people going to move towards it? And you think about
Stories.
the law, which is like a pessimistic, risk-averse kind of process. I need to protect you, my client, from things going horribly wrong. So let's think of all the terrible things that could happen and sort of chastise the other person in advance before they do anything bad. So
It's set up as
Why
adversarial.
would life get better?
Yeah.
When there's no talk of it being better, there's only talk of it being worse.
But the language point is relevant because although the MOJ are promoting the earlier resolution, they call anything sorted out before a court case or before a hearing non-court dispute resolution. Now, that keeps the word court in the frame.
Yeah.
And the word dispute.
And the word dispute. So everything about the term non-court dispute resolution is reprehensible to the kind of values that we espouse, because what we would like to call it is the family solutions, the opportunity for families to find their own solutions.
Yeah.
Let's talk about it positively rather than, it's a kind of reverse repel
I
out
guess
of
I'm
court.
almost saying could
But
be
that's
worse.
how
It's
lawyers
like
think.
It could be
we've given
worse.
you
It's
the
about
other
as
option.
complimentary as they get.
It is, but the kind of awareness that actually that is a really awful term is non-existent. That's what they've done, and everything is framed in the shadow of the
court.
family court.
So coming back to that, when you're saying that court is this kind of be all end all, this is this major thing looming all over us, and then you've kind of got non-court dispute resolution. It's interesting when you're talking about the difference there. How do we move from one to the other to have non-court dispute resolution as the main body? Like what is the solution there to have that move to the main body rather than
perhaps why don't we call it family repair rather than non-court
family solutions is how
just
I
talk
see
about it being better right from the start rather than frame it as a non-court thing. It's still
unbelievable,
it's
really.
not in the court, but it's still not good.
Yeah, that's
it just
so
kind of
it's terrible.
So it's like almost like it's like this, we'll just give you the non-court, you're easy, so we'll just give you the non-court dispute resolution option. It's like another tool rather than the court. It's like lawyers see it as something extra that they can use rather than the main mandatory aspect of it.
The new rules are good on paper, apart from the terminology, which is awful.
Yeah.
But on paper, the new rules are good in putting the burden on all parents and indeed their legal advisors, whether it's solicitors or barristers, to have a responsibility to consider whether they can resolve issues away from court rather than just turn up at court hearings. And, I think the aspiration behind the rules is good.
Yeah.
The delivery of the rules
there's
is
no
poor.
how, is there?
No, and it's a bit like the Children Act, the welfare principle. It's great. By the way, everything I say is in the context of private family law. And for those who don't know what that is, that's just issues that parents have between themselves, not their children being vulnerable and being under a care plan with the local authority or child protection issues. I'm just talking about non-safeguarding cases where parents can't agree things. That's sort of my area. But in that context of parents can't agree things, there should be, in my view, a language that is very, very clear for parents to understand. We have a space in which family solutions are encouraged. I think of it as the family solutions space. And then separate to that, we have the family court.
Yeah.
What we do have at the moment is this blurred messaging around the family justice system. Well, A, it suggests there's a system when there isn't for a lot of it. B, it suggests it's about justice when it isn't for a lot of it. And C, it imposes the language of law and justice on a whole gamut of situations, many of which aren't about law and justice. They're about pragmatic solutions, best outcomes, family repair. And so I think the more that people like us can be very specific because until we get MPs understanding this, everything is always directed back to the MOJ. So we had an example recently where one of our fabulous members of the Family Solution Group, in desperation, wrote to the Prime Minister's office to say, we published a fantastic report, A Child's Right to Matter. It's a great report, came out in 2023.
Mm-hmm.
Had lots of stuff about children and their needs and how they're overlooked. And it was a previous government, given that we now have a different government, she wanted to bring the report to the Prime Minister's attention. We got a very polite message back from the Prime Minister's office, acknowledging the importance of supporting children and having directed it to the relevant department. Well, guess which relevant department?
Ministry of Justice.
Of course, goes. And we got a letter from the Ministry of Justice saying, thank you very much. You know, we'd like to assure you of the great work we're doing in promoting the Pathfinder Court. So the Pathfinder Courts are a new initiative, and I think great, absolutely fantastic, with the Child Impact Report right at the beginning. So they're a great improvement to the traditional family court, but they are the family court.
Yeah.
So I said to Bill earlier, it's a bit like asking the MOJ, how do we get to Brighton? And they say, well, we're doing some great things in Bristol. You know, that's no help when we want to go to Brighton. How do we help families solve issues away from court? How do we help children know their rights and get the support that they need?
Yeah, I mean, I know there's a certain type of thinking that comes with certain professions, and I know there are kind of aspects to that that are sometimes problematic because you want to bring in a therapeutic kind of way of thinking, but there'd be like a concern about, well, what if you were to do something that didn't go well and everyone have to deal with so again, it often seemed to me when I was looking at mediation training that was kind of like a case of better to do nothing and not cause any harm than to do something, to sort of take a risk or to use your own kind of professional intuition in terms of how to manage something. There did seem to be an awful lot of, no, don't do that because you might make it worse. The problem for me is that if you are sort of driven by not making it worse, you're very unlikely to make it better.
Yeah.
Because actually make it better is not easy because you've got people already in a state of mind where they're quite fixed and quite stuck. So if you try to sort of very mildly get them to consider that they might look at things differently, they're simply not going to be invited or in any way interested in such a proposal. You've got to actually be quite sexy. You've got to be quite exciting. It's got to be quite tangible and concrete, which kind of, is the law in some ways is more appealing because it's more
Structured.
It's structured and it's solid and it's got divinity attached to it. Okay, there's lots of collateral effect, but mediation seems to me to be. I remember once there was someone did some research into how mediators were responding when requests were made to them about how, whether someone might use them as mediators or not. And the person was listening not to the words that were used, but the tone of voice.
Oh, that wonderful research. I remember that.
Yes. And the mediators were persuading the clients not to use them.
Yeah.
Saying, oh, no, it won't be good and you've got to think about this and you've got to think about that. So I kind of feel that there's too much risk aversion and too much fear and not enough freedom to be expansive and creative.
Do you think that comes from the idea that, this is obviously under the barrier of law and that is quite risk averse and very particular about ways things should be done, and it doesn't have a lot of freedom to it because that's not the way that works. It's not the way it's built. So is it asking too much of it to become like that, and really we need something else? And I
but
feel
to
like that's
allow
what
it,
you're saying.
like you were saying, it's like allowing psychology in a therapy. You are very much encouraged to use your kind of intuitive responses. So follow the flow, if you like. Someone says something and you follow it. So you're very kind of loose and free to sort of go wherever it needs to go, with a strong sense of safety in terms of, you intuitively know what would be unsafe to kind of cover and what wouldn't. You don't have to have guidelines that are very exact and concrete. You must do this, you mustn't do that. So in a therapeutic environment, there's a very strong sort of culture of constant progression and constant learning and constant growth and constant ability to get better and better and better at being a therapist. I kind of feel that isn't really part of the sort of mediation culture. I mean, maybe with some, but there are pockets. If you look at the overarching sort of accreditation guidelines, there isn't much expansive, creative freedom to move, it seems to me, in that sort of culture. And whenever I kind of talk to a mediator about their work, we very often get to the point where they're saying, I can't do that.
That's interesting. I think I see it differently. I maybe hang out with different mediators. We're part of a little practice down in Kent, and I think one of the challenges for many mediators is that they work on their own, whereas being in a team makes such a difference. And we share each other's. If you have a difficult discussion or a difficult thing, you can bring people in as well to co-mediate if you need to. There's a team learning and growing and developing as a team. I think a lot of mediators are set up in practice on their own, and that's pretty hard, and that perhaps undermines confidence. But I see a huge difference between the mediators who just work as mediators and the mediators who are having to navigate the dual profession. I just think that's more complicated.
I'm sure it is.
Yeah.
I'm sure it
And
is.
is that because you're having to put on two different brains almost, or you're
Different
doing
professional boundaries.
Yeah, so you really are kind of fighting against each other every time you go from one to the other.
Well, I always try and avoid battle language, but
That's probably a good thing, talking about positive language.
it's extraordinary how battle languge does
into it.
creep into this part of life in
Yeah.
so many ways. Like the when we're working with parents and they talk about sides, and I think, who introduced the concept of sides here?
I think that
it's
comes
very
from
binary. We don't have sides.
the kind of idea that divorce has always been one side v the other side, and you
Yeah.
have two lawyers and they're kind of having a battle between each other. Does it come from that, the idea of that?
I think also just the way you feel when you're in conflict. You feel alone. You feel that the other's not supportive of you. You feel the other person doesn't have your best interests at
But
heart. There's a natural...
That's in court.
Well, no, even just in your head. Like if you're in a relationship that's not going well,
Yeah.
and you're feeling the other person isn't really concerned about you or interested or doesn't like you, you're going to start sort of
But
arm
isn't it
yourself to some extent.
our role, isn't it, is to deconstruct sides and have that kind of collaborative, we all want the best for little Johnny. Let's describe how, he would describe his childhood in 20 years' time when he looks back. And then how do we get there? And there's so much that we do, which is deconstructing the cultural norm of structure, positions, side, defensiveness, battle language. Even if you look at the legal directories, they use terminology around, she's a great lawyer, you want her in your corner, and you think,
Corner?
yeah, this isn't a boxing ring. Let's get that family out of the boxing ring and sit them around the kitchen table and give them all a cup of tea and talk about how we can resolve this. And I think the voice of the child and the feedback coming back to that is the greatest tool we have.
I 100% agree
parents
with you. Why on earth?
engage
the children's
with their
voice isn't
brain.
involved in every case. I don't know. People are making their own lives a lot harder by not introducing the children's voice.
And now it's upfront. It's part of the way I present the principles of mediation in the first 2 or 3 minutes of the mediation. And I describe it as the three-legged stool and the importance of it. And they all say yes.
Yeah.
And we, as child inclusive mediators, need to step up to present this in a way where parents don't feel nervous and where they say yes, because otherwise the adults are silencing the children. We've got to be clear about that. The children have a right to be consulted. They do. We have it in English legislation, and we have it in the science, and we have it in the UN Convention. everything points to the children have a right to be consulted. Why is it okay for the adults to continue to silence them? And, we need to be much braver. But the irony is, as you say, Bill, is that is the transformational thing, quite apart from the human rights of the child and the importance of for the child welfare. Actually, it's the thing that shifts the mindsets more than anything else.
So do you think the lawyers need to be very much involved in having training in that and being able to explain that properly and do that right at the beginning, so that can be the first step in allowing parents to then be involved in it and see the importance of it?
Well, we just hosted an online conference called Children's Voices in Family Separation, specifically to promote the need for solicitors to include the voice of the child in the work they're doing with families out of court, because there's a lot of really good work done by solicitors, which isn't in mediation for perfectly good reasons, I'm sure, but aren't in court. But they don't have a process, they don't have a template for bringing the child's voice into that. So we've spoken to the president of the Family Division and Mrs. Justice Knowles at the time, and it all should come under the banner of child inclusive mediation. So, for instance, if Mitch, if you and I were solicitors, each representing a parent, what we could do is talk to our clients and say, your children need to be consulted while we discuss these issues that we're discussing, be that finance or children, frankly. We recommend retaining Bill as a child inclusive mediator to offer to meet your children, hear what they have to say, and with their permission, give feedback to our clients and us, the solicitors.
Yeah.
And there's a template for that. There's a protocol. It's all there on the Family Solutions Group website.
It's kind of a grassroots kind of revolution in a way, where rather than waiting for guidance from above,
there will never be guidance.
Practitioners on the ground start to increasingly, I feel, go against a culture of fear or caution, which I think is really
interesting. We had a lot of people sign up to this conference, and it was introduced by the president of the Family Division. He's a very strong advocate of child inclusive mediation, and says that any mediator that's not really offering it is going to fall behind the way life is going, because it's now at the front of the Pathfinder courts, the child impact statement. And here we also had a High Court judge speak, and I was expecting a discussion around the importance of hearing the voice of the child in out-of-court options, what they call non-court dispute resolution. The NCDR work should include the voice of the child as a matter of course. It's not something you just leave to Kafkas.
Yeah, every time.
In any family work going on outside court, if there are children of an appropriate age, where are they being consulted, and how is that feeding into the decision making? That. Anyhow, but you're right. I mean, her talk was a very legally brilliant talk about the nervousness that people feel about listening to children's evidence in court, and she even cited a judge in a criminal case, very serious criminal case, where there were allegations of child sexual abuse and the extent to which the child's evidence could be relied on, and some really learned things from the judge in that. Now, these are all really complex areas, and it's why I said before, the family court judges need the wisdom of Solomon in the cases. But of course, that's not what we're talking about. We aren't talking about allegations of child sexual abuse in a criminal case. We're talking about having a chat with a girl about whether she wants shampoo or conditioner separate altogether at her dad's house. We're talking about non-safeguarding cases. Safeguarding cases probably need to be in court. Query that. Bill may not agree. But we're talking about the everyday cases where parents need some help, children need to be consulted, and the professionals need to be listening to children and bringing that in. These aren't the serious cases. But I think if you're a judge who's used to hearing complex cases, which they do, and they, as I say, it's a brilliant job they do.
That's where they're.
It's almost too hard to think of just the kind of informality of the kind of chats that we have with children.
We, in our child inclusive practice, we ask children what their 3 wishes are for their family going forward. So I'm going to ask you to finish up what your 3 wishes are for separating families or the family justice system going forward.
What a fabulous question. Well, at the Children conference recently, it closed with a lovely person called Shakira on the panel. By the way, I must just highlight the fantastic workshops being run for young people by Your Direction. Any child aged 11 to 18 or a separate group for 19 to 30-year-olds. There's these online workshops, just absolutely brilliant for them, being run by Your Direction. Anyhow, Shakira is involved in that work, and she's a child of divorced parents. And she finished the conference by saying, what we'd love is a bit more kindness. And I think, these restoring the context of humanity, love, kindness to parents who are afraid, who are nervous, who are defensive, who are angry, who are raging, who are doing all kinds of things, but restoring some of actually what they really want for their children as mainstream. So that would be my number one in a way. How to get there, leave the MOJ doing what they do best, which is run the family court and deal with the really, really difficult cases and have their brilliant judges doing the really hard work that they do, and remove all other aspects of family separation away from the Ministry of Justice. Personally, I think it sits naturally under the Minister for Children and Families. At the moment, that's being resisted. But family separation raises multiple needs. So I think we need it away from the lens of justice and law and seen as a kind of human issue that people go through. And as you say, Bill, that can be with a future that they have autonomy over, that can be positive. It doesn't have to be the shaming, terrible thing. And I suppose the other thing I would love to see more of is stories. Stories of the young people, stories of resolution, stories of hopes, stories of I suppose, restorative justice in one sense, but that brings in the justice word, stories of restoration. And we hear them and we see them. We hear them in the workshops. We see them with our clients all the time. So we need all the work that we're doing to be told. And we, the professionals, need to be telling our stories. So I think restoring kindness and humanity, taking family separation out of justice into the Children and Families Minister. And I think all of us need to be telling our stories, and primarily telling the stories of the young people, the stories of the shampoo and the carrot cake and the everything else, because then we see it through the child's perspective.
Yeah.
And that will be ultimately what shifts mindsets.
Well, thank you so much for your time, Helen. Thanks for joining us on Conflict to Connection. We hope today's episode gave you some fresh insights to help you navigate your journey. If you found this helpful, don't forget to subscribe or follow the podcast and leave a review. For more resources and support, follow us at Civilised Separations on Instagram, TikTok and LinkedIn. You can also visit our website at civilisedseparations.co.uk. See you next time, where we'll be exploring ways to build stronger connections for a brighter future.